Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements and also to navigate through the intricacies of the insolvency proceedings. Let us discuss one such case today. So this is the case of Bharti Airtel Limited versus Vijaykumar Iyer. So this was decided on 3rd of January 2024 by the Honorable Supreme Court of India. So in a recent matter of Bharti Airtel Limited and another versus Vijay Kumar B. Iyer and others, a two-judge bench of the Supreme Court passed a judgment dated 3rd of January 2024 and made observations regarding the right of a creditor to claim set-off of any amount that it owes to a corporate debtor against the debt owed by the CD to such creditor post-commencement of the insolvency proceedings. Now, what is the factual background of the case? In the present case, the appellants, that is Bharti Airtel Limited and Bharti Hexacom Limited, which is the Airtel entities, executed 8 spectrum trading agreements with Aircel Limited and Dishnet Wireless Limited, which is the Aircel entities, in April 2016 for purchase of right to use the spectrum allotted to the latter in the 2300 megahertz band against payment of rupees 4,022 crores to the Aircel entities. However, the said agreements were contingent to the approval of the Department of Telecommunications, Government of India. The Telecom Department demanded bank guarantees in relation to certain license dues and spectrum usage dues from the Aircel entities. Aggrieved by such demand, the Aircel entities approached the Telecom Dispute Settlement and Appellate Tribunal, which is TDSAT. Now, TDSAT wide order dated 30th of June 2016 directed the Aircel entities to submit the bank guarantees. But the Aircel entities did not have the means to procure and submit the bank guarantees worth approximately rupees 453 crores. Hence, they approached the Airtel entities for submission of said bank guarantees on behalf of the Aircel entities to the Telecom Department. The Airtel entities executed letters of undertaking whereby they agreed to furnish the bank guarantees to the Telecom Department on behalf of the Aircel entities, provided the latter deducted rupees 586 crores from the amount of consideration payable by the Airtel entities under the spectrum trading agreements. Later, TDSAT, by order dated 9th of January 2018, directed the Telecom Department to return the bank guarantees to the Aircel entities. However, the bank guarantees were not returned, and the Telecom Department filed civil appeal before the Supreme Court. The Aircel entities also filed cross appeals before the Apex Court. Now, the Honorable Supreme Court, wide interim order dated 28th of November 2018, directed the Telecom Department to return the bank guarantees to the Aircel entities as per TDSAT order dated 9th of January 2018. But the Telecom Department did not return the bank guarantees. In view of the aforesaid, the Airtel entities approached the banks seeking cancellation of bank guarantees. As the banks were reluctant, the Airtel entities approached the Apex Court, which, wide order dated 8th of January 2019, directed that the bank guarantees must be cancelled and the same cannot be used for any purpose. Thereafter, the accounts between the Airtel entities and the Aircel entities were settled. And as per the Airtel entities, rupees 145 crores was the net amount payable by the Aircel entities towards operational charges, SMS charges, and interconnect usage charges to the Airtel entities. Now, in the meantime, a CIRP process was initiated in respect of the Aircel entities before the Honorable NCLT Mumbai bench under Section 10 of the IBC. The Airtel entities submitted their claims before the RP, which were admitted to the extent of rupees 112 crores. However, by letter dated 12th of January 2019, the RP sought from the Airtel entities a sum of rupees 112 crores payable to the Aircel entities under the spectrum trading agreements, consequent to the discharge and cancellation of the bank guarantees furnished by the Airtel entities, failing which the RP would take steps for recovery. Now, the Airtel entities objected to the RP's demands on various grounds and also claimed set-off of the amount due to them by the Aircel entities from the amount payable by them to the Aircel entities. However, the Airtel entities' claim for set-off was rejected by the RP. Aggrieved, the Airtel entities approached the NCLT, which by order dated 1st of May 2019 held that the Airtel entities had a right to set off rupees 112 crores that was payable to the Aircel entities from the amount due and payable by the Aircel entities to Airtel entities. Aggrieved by the Honorable NCLT order dated 1st of May 2019, the RP filed an appeal before the Honorable NCLAT. The Honorable NCLAT, by order dated 13th of July 2020, allowed the appeal against the Airtel entities. Now, let us understand what is the set-off under IBC. Now, there is a difference of treatment of set-off under CIRP and liquidation. CIRP focuses on revival and rehabilitation, while the liquidation process focuses on distribution and payment out of the sale of assets. IBC, like Companies Act, does not give right to a debtor to set off. But under liquidation process, Section 36, subsection 4, permits the IBBI to specify assets which could be subject to set off on account of mutual dealings between the corporate debtor and the creditor. IBBI has framed liquidation process regulations which permit set off during liquidation under Regulation 29. In the case of partnerships and individual bankruptcies also, Section 173 of the IBC permits set-off. Now, let us see what are the observations of the Honorable Supreme Court. Now, the Apex Court passed an order dated 3rd of January 2024 and made the following observations. That the term set-off generally recognizes the right of a debtor to adjust the smaller claim owed to him against the larger claim payable to his creditor. In Law Order 8, Rule 6 of the CPC provides that where a suit for recovery of money has been filed, the defendant can claim a set-off against the plaintiff's demand for a certain sum of money that is legally recoverable by the defendant from the plaintiff, provided that the claim for set-off arises out of the same transaction. The defendant may also claim an equitable set-off for a certain sum of money, wherein such claim must have a connection between the plaintiff's claim for the debt and the defendant's claim to set off. However, legal set-off as distinguished from equitable set-off is allowed by court only for a certain sum of money and is a statutory right. On the other hand, insolvency set-offs are applicable where demands for the claim for debt and the claim for set-off against such debt are between the same parties, and there is a commonality of identity between the person making the claim and the person against whom the claim is made. However, upon commencement of CIRP process, the identity of a CD changes, and as a result, the set-off of the dues payable by the CD prior to the commencement of CIRP cannot be made from the dues payable to the CD post the commencement of CIRP. Otherwise, in the event that cross demands are set off, the assets available for distribution amongst various classes of creditors would be depleted in favor of a single creditor with a set-off entitlement. In other words, it puts and grants priority to the creditor, even an operational creditor, to the extent of the set-off. This cannot be allowed as it would be contrary to the pari passu principle embedded in IBC, such as in Section 53 of IBC, that creates a hierarchy of stakeholders with the stipulation that each class of creditors shall rank equally among each other and shall be given equal treatment as the creditors of such class. Thus, the right to set off, being an equitable right, can be denied if such grant of relief would defeat equity and justice. Furthermore, the bench held that the set-off obligations maturing prior to the commencement of CIRP may only be allowed, whereas the set-off obligations arising after the commencement of CIRP should be disallowed or allowed to a limited extent in order to ensure smooth insolvency resolution process and rehabilitation and revival of the corporate debtor. So we conclude that applying the aforesaid principles to the present case, the Honorable Supreme Court held that consequent to the orders passed by the Apex Court, vide orders dated 28th of November 2018 and 8th of January 2019, in respect of cancellation and return of bank guarantees to the Airtel entities, the latter became liable to pay the Aircel entities in terms of the letters of undertaking. Further, such amounts became payable post commencement of CIRB, that is after 12th of March 2018. Thus, the bench held that the relief of set-off cannot be granted to the Airtel entities. As a result, the appeals filed by the Airtel entities were dismissed. So friends, we see here how the Honorable Supreme Court has clarified the principle of set-offs under IBC while upholding the sanctity of the Section 53, where the stipulations regarding the hierarchy of the stakeholders is given. So thank you, friends, for being with me here today. This is Deepika B. Prasad signing off. We'll catch you in the next case. Thank you.